Imagine sitting in the back of a police car. Your heart is racing, the flashing lights are reflecting off the windows. An officer turns around and asks you a simple question. Do you want to tell me what happened? It sounds harmless, almost casual, maybe even helpful, but in that moment something extremely important is at stake, something most people think they understand, but actually don't. Your right to remain silent. You've probably heard the phrase hundreds of times in movies, TV shows, and viral videos online. You have the right to remain silent. Anything you say can and will be used against you in a court of law. It's so familiar that many people assume they fully understand what it means. But here's the uncomfortable truth. Most people misunderstand this right, and that misunderstanding has quietly put thousands of ordinary people into legal trouble. People who believed they were cooperating, people who thought answering just a few questions would help them, people who assumed that telling their side of the story immediately would clear things up. Instead, those words ended up becoming evidence. So here's a question for you. Before we go any further, think about it honestly. If a police officer starts asking you questions, do you believe staying silent will make you look guilty? Go ahead and pause for a second and answer in the comments. Because that exact belief is one of the biggest misconceptions about the justice system. And tonight we're going to uncover the truth behind one of the most famous legal rights in modern history, where it came from, why it exists, how it actually works in the real world, and the surprising ways people accidentally give up that right every single day without realizing it. To understand the right to remain silent, we need to travel back centuries before police cars, before courtroom dramas, and before the famous warning we all recognize today. The roots of this right go all the way back to a time when speaking could literally mean your death. In medieval England, the legal system looked very different from the one we know today. Courts often relied on forced confessions. Suspects were pressured, threatened, and sometimes tortured until they admitted guilt. In many cases, refusing to answer questions was itself treated as evidence of guilt, and in some brutal situations, defendants were physically punished simply for refusing to speak in court. One particularly disturbing practice known as peine forte dure involved placing heavy stones on a suspect's chest to force them to enter a plea. If they refused to speak, the weight increased. This method was designed to break silence, and it reflected a legal philosophy that dominated early justice systems, the belief that silence must mean guilt. Over time, however, society began to question that assumption. Legal thinkers started recognizing something important. Confessions obtained through pressure, fear, or coercion were often unreliable. People under extreme stress will say almost anything to escape the situation. Gradually, the idea began to emerge that individuals should not be forced to accuse themselves. This principle eventually became known as the privilege against self-incrimination, and it would later become one of the foundational rights in modern legal systems. When the United States Constitution was written in the late 1700s, the authors included this principle in the Fifth Amendment. It states that no person shall be compelled in any criminal case to be a witness against himself. In simple terms, the government cannot force you to provide testimony that could help convict you. But here's something many people don't realize. For a long time, that protection existed mostly in theory. Police officers were not always required to inform suspects about it, and many people simply didn't know the right existed. That changed dramatically in 1966 with a landmark case that reshaped criminal procedure across the United States. A man named Ernesto Miranda had been arrested in Arizona and interrogated by police for hours. During that interrogation, he eventually signed a written confession, but the police had never informed him that he had the right to remain silent, nor had they told him he could request a lawyer. Miranda's confession was later used against him in court. He was convicted. But when the case reached the United States Supreme Court, the justices focused on something deeper than the confession itself. They focused on the process. The court ruled that suspects must be clearly informed of their rights before custodial interrogation. From that moment forward, the now famous warning became a standard part of police procedure. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided for you. Those words became one of the most recognizable phrases in legal history. But despite how famous the warning is, confusion about it has never disappeared. In fact, in some ways, it has increased. Movies and television often portray suspects dramatically refusing to speak, but real life is rarely that clear-cut. The right to remain silent is not a magical shield that activates automatically. In many situations, you must actually invoke it, and that distinction has led to countless misunderstandings. Imagine a scenario. A person is questioned by police about an incident. They respond to some questions. They hesitate on others. They say things like, "I don't know," or "maybe." Later, when the case reaches court, prosecutors may argue that certain statements contradict each other. Those small inconsistencies can become powerful evidence. What began as an attempt to explain the situation becomes a puzzle of statements that lawyers and investigators analyze carefully. This is why many legal experts emphasize a simple principle. Silence cannot be misquoted, statements can. Another surprising reality is that people often talk because they believe silence makes them appear guilty. Psychologically, that instinct is very strong. Human beings naturally want to explain themselves. When accused of something, our first impulse is to defend our reputation. We want to tell our side of the story. We want the other person to understand. But legal professionals frequently point out that police questioning is not the same as a casual conversation. Investigators are trained to gather information. They listen carefully. They compare statements. They may already have evidence that the person being questioned doesn't know about. And even honest mistakes in wording can later appear suspicious when taken out of context. Think about how often ordinary conversations include small inaccuracies. We estimate times, we misremember details, we confuse sequences of events. In everyday life, those mistakes rarely matter. In legal situations, they can matter a lot. This doesn't mean police questioning is inherently unfair. Investigators have an important role in solving crimes and protecting communities. But the legal system recognizes that individuals should have the choice not to answer questions that might affect them legally. That is precisely why the right to remain silent exists. It creates balance. The government has the power to investigate. Citizens have the right not to be compelled to contribute to their own prosecution. Yet, despite that protection, countless people waive the right without fully understanding it. Sometimes they do it because they feel pressured. Sometimes they do it because they think cooperation will help them. And sometimes they do it simply because they don't realize the conversation has legal significance. Consider how many viral videos show roadside encounters with law enforcement. Drivers or passengers are asked questions. Some respond casually. Some become nervous and talk excessively. Others attempt to explain every detail of where they were going, what they were doing, and why. In many cases, the situation might be resolved quickly. But occasionally, those conversations later become part of a larger investigation, and when recordings or reports are reviewed, every statement can be examined. This is why legal educators often emphasize clarity when discussing constitutional rights. Invoking the right to remain silent typically requires a clear statement. Courts have ruled that ambiguous responses are not always enough. In other words, simply staying quiet without clearly expressing the intention may not always activate the legal protection. This nuance surprises many people. They assume silence alone is sufficient. But legal interpretation can depend heavily on the exact circumstances. Another common misconception involves the idea that silence automatically ends questioning. In reality, police officers may continue asking questions. The right protects you from being compelled to answer. It does not necessarily stop officers from attempting to gather information. Understanding this distinction helps explain why legal experts emphasize careful communication during serious encounters with the justice system. But let's pause here for a moment. Think about your own assumptions. Before hearing this explanation, what did you believe the right to remain silent meant? Did you think it simply meant not talking? Or did you know that invoking it clearly can matter? Share your thoughts in the comments, because the gap between what people think the law says and what the law actually says can be surprisingly wide. And closing that gap is one of the most powerful forms of legal awareness. Another important aspect of this right involves timing. The famous Miranda warning is typically required during custodial interrogation. That means when a person is both in police custody and being questioned. But outside that specific situation, the rules can look different. Casual conversations with officers in public spaces may not require the same warnings. This is another reason legal experts emphasize awareness of context. A conversation that feels informal may still have legal significance, and once statements are made voluntarily, they can sometimes be used later. Understanding these distinctions doesn't require a law degree, but it does require careful attention. The justice system contains many layers of procedure designed to protect fairness. Rights exist within those procedures, but they are most effective when people understand them. There is also a deeper philosophical dimension to the right to remain silent. At its core, it reflects a fundamental belief about power and individual liberty. Governments have enormous authority. They can investigate crimes, gather evidence, and prosecute cases. But the principle behind the Fifth Amendment draws a line. It says the government must prove its case using its own evidence. It cannot simply force a person to supply the proof against themselves. That idea has influenced legal systems around the world. Different countries apply it in different ways. But the underlying principle, protecting individuals from compelled self-incrimination, remains a cornerstone of modern justice. Of course, the right to remain silent is not absolute in every situation. There are circumstances where individuals may be legally required to provide certain types of information, such as identifying themselves during specific lawful stops, depending on local laws. Legal frameworks vary across jurisdictions. This is why understanding local laws and consulting qualified legal professionals is always important when serious legal questions arise. Still, the central message remains clear. The right to remain silent exists to protect fairness in the legal process. It recognizes human nature. It acknowledges that people under pressure may speak in ways that later harm their own defense. And it ensures that the burden of proof remains where the justice system places it, on the prosecution. Yet perhaps the most fascinating aspect of this right is how often it collides with human psychology. Silence feels uncomfortable, especially when authority figures ask direct questions. We are raised to respond, to explain, to justify. Remaining quiet can feel unnatural, even suspicious. But in the context of legal rights, silence is not an admission of guilt. It is the exercise of a constitutional protection. That distinction is one of the most important lessons legal educators try to communicate. Because once a statement is made, it cannot be taken back. Words become part of the record, and records can follow a case for months or even years. So the next time you hear those familiar words in a movie or on television, you have the right to remain silent. Remember that they represent centuries of legal evolution, from the harsh interrogations of medieval courts to the constitutional debates of the 18th century to the landmark Supreme Court decisions of the 20th century. The right emerged from a long struggle to balance justice and liberty. It exists not to obstruct investigations, but to protect the integrity of the legal process. And perhaps most importantly, it exists to remind us of a simple principle. In a fair system of justice, the power of the state must always be balanced by the rights of the individual. Now I'd like to hear from you. Before watching this, what did you think the right to remain silent actually meant? And do you think most people truly understand how it works in real life? Share your thoughts and experiences in the comments. Because conversations like this help transform legal rights from words on paper into knowledge that people can actually use to understand the world around them.